that takes us to the next trend, which is really dealing with privacy and how privacy and discovery can remain in tension here. This is something Ray and I been writing about for a number of years. First, we wrote a piece in the Sedota Conference Journal, and then more recently, we published really a Counterpoint series of articles in Judiciary magazine, which is a magazine for the judiciary, the judges, and just really gives kind of the thought about how privacy and discovery interrelate and how, in fact, requests that implicate privacy can make those requests not proportional. Ray, you want to give a little more context there?
Yeah, I mean, as Robert said, this was in judicature. They did a counterpoint. So on the point side was our piece that was titled "The Burden of Privacy and Discovery," and for the counterpoint, it was a very thoughtful piece by Judge Rosenthal and Professor Steven Gensler called "The Privacy Protection Hook in the Federal Rules." I'll try to summarize both sides here. I would really encourage people to read both of these articles. I think it's an interesting area, and I think there are interesting points on both sides. You know, on our side, we're focused really on the idea that privacy can be considered as an aspect of proportionality discovery, and we give many reasons for that, but I'd say one of the core reasons is that we have a textual hook in the rule itself that we can point. And if you look at Rule 26b1, it defines the scope of discovery. And in order for information to be within the scope of discovery, it's got to be both relevant and proportional. So it has to be relevant and proportional. It's not just defined by relevance. It's also defined by proportionality. If it's not both, then it's not discoverable. In the article, we take a look back at the history of proportionality, how it got introduced into the rule, there's actually a list of things that define what is proportional or aspects of proportionality in the rule and how those got added and rearranged. And we focused on the last proportionality factor, at least as the proportionality factors are ordered today, which is whether the burden or expense outweighs the likely benefit. And in our view, that's a pretty broad catch-all, and it talks about burden or expense. So burden, being different from expense, could include a broad range of non-financial burdens. And one of those burdens can be the burden of privacy. And we also go beyond just the textual argument and talk about how it makes sense to treat this as an aspect of proportionality. It's not that just because something is private that it's not discoverable. It just kind of gets thrown into the mix. And it's one of many things we should consider in figuring out whether discovery is proportional or not. Now, on the other side, Judge Rosenthal and Professor Gensler, and apologies to them if I don't do their argument justice, I will do my best. They would say, look, privacy, we already have a rule for that. That's why we have Rule 26C, protective order. If you have these concerns about privacy, you can get a protective order, and that if those privacy interests are genuine and if they're significant, you should be able to get a protective order for that. So at a minimum, these privacy concerns, even if they're important issues, even if they should be included in the rules, maybe they should even be included in Rule 26b1, they're not there yet. Say Keeling and Magnum are reading too much into this one word. And Judge Rosenthal was involved as part of the drafting of the rules, and she would say, and privacy just wasn't part of the discussion. So if we're going to make privacy be a factor in defining the scope of discovery, we should have that discussion, and it should be explicit into the rules, and we shouldn't do the strained reading that Keeling and Magnum are doing. So, I think there's great points on both sides. Obviously, I'm a bit biased. I think we have the better of the argument, but I do encourage people to read both of those.